Good evening, my fellow Ghanaians. Welcome has been characterized by many upheavals of different sorts, not least that to do with the voting rights of deputy speakers of parliament, which, thanks to a certain electronic levy, has been the bane of the august house, literally bringing parliamentary work to a standstill and government business to its knees. With item from the 1992 Constitution of Ghana, the matter was put before the apex court of the land concerning what was right to be done. Among other things, whether or not a deputy speaker or person presiding over proceedings in parliament retains or loses his or her right to vote. The Supreme Court, in a unanimous decision, jettisoned the traditional outlook of the House throughout the 7 prior parliaments of the Fourth Republic and indicated that per its reading and in conformity with the true letter and meaning of the supreme law of the land, the proper interpretation of the said articles point to the fact that the deputy speakers do not the many rancorous scenes we have witnessed in this 8th parliament. Some ask, why now? Others point to some grey areas which are not answered by the apex court's ruling. Did the court then lose sight of some crucial issues which could come back to haunt not just parliament, but the whole business of the House? Still others opine that the ruling was judicially biased and that executive strings were pulled in order to make the judiciary bow to its co-entities in Parliament, the NPP and the NDC, find middle ground, if any. And what, ultimately, does the ruling of the Supreme Court mean for parliamentary work moving forward? We are joined by our guests to properly interrogate the ins and outs of the matter. We're live on Joy 99.7 FM, Love 99.5 FM in Kumasi, DSTV channel 421, GoTV channel 144, and myjoyonline.com. Stay with us. I shall, flowing from your questions, probe these pivotal issues together with my guests right after the break. Stay. Welcome back. You're still live on the probe. And tonight we get into that all-important matter on the back of the Supreme Court's ruling. What does this really imply for us? Parliament's Constitutional Legal Committee will now have to sit, deliberate on these, and map the way forward in terms of the standing orders. Fortunately, we have the men to do justice to this very topic. We have Dr. Rashid Draman, who is with the Africa Center for Parliamentary Affairs. He will join us from the standpoint of one who has followed these matters when it comes to parliaments, not just in Ghana, but beyond. We also have, from the minorities end, Roxanne Nelson Dafiamekwo member. On the other end, we have Kwame Anyimadu Entry, who is actually chairperson, Constitutional Committee on Legal and Parliamentary Affairs. We'll also have the man who actually brought this to the fore, who petitioned the court to look into the matter of the right. Our guests will be joining us via Zoom, some of them via phone if need be, but joining us here in the studio, Roxanne Nelson Dafiamekwo, Member of Parliament for South Dai, and also a member of the Constitutional Legal and Parliamentary Affairs Committee of Parliament. For those of you on Zoom, just to check, an audio check and a visual check as well. Good evening to you. So you would have to unmute, both of you. Please unmute. You are able to do that. We shall get your feed back. Let me come into the studio quickly. Roxanne Nelson Dafiamekwo is here. This is the second time in a span of days that we're interacting on this matter. Thank you so much for joining the conversation.
My pleasure. Good evening to you and good evening to my viewers, especially my
views. We've got to the point where this has become a very topical matter. Everybody, even those on the streets, are talking about it, and rightly so. Now, speaking to me a few days ago, you called the Supreme Court and upon further reflection,
yes.
Have you had a change of heart, maybe, in terms of those words that you used?
Not at all. Indeed, it was as though I had read the decision in full. My opinion has been fortified by the contents of the ruling.
How so?
And I would demonstrate wrong. It was legally wrong. It was jurisprudentially wrong. And also that it was a judicial coup d'etat against Parliament, as well as finally that it was a judicial blessing to chaos that could be generated in Parliament. Now, you have a Supreme Court that says that our two deputy speakers, the first deputy speaker and the speaker's seat,
Right.
will be ascribed with voting rights. Now, what that means is that by application of our standing orders, the application of our standing orders applies to our proceedings at the committee levels, mutatis mutandis. Okay? So, for instance, at the committee level, we have this. So, he is the chairman of the Standing Orders Committee.
Exactly.
Okay? With the two deputy speakers also as members. I'm also a member of that committee.
Right.
We handle the rules, the standing orders.
Basically.
Whatever amendments or whatever. Or everything about our standing order, rules, procedure, everything in Parliament is the preserve of this committee. Now, by our practice, the chairman hasn't got original vote, but he has a casting vote. A consequence of the present decision of the Supreme Court, it means the chairman will now have both an original vote and a casting vote. Now, the two deputy speakers who are members from Bekwai and Formina respectively are also members of this committee. Now, the speaker as well is the chairperson or the chairman of another committee, okay, which is the committee on, if I may quickly, I'll come back to mention the other committee that is the chairperson of.
Right.
Then the first deputy speaker is also a chairman of two committees, the appointments committee as well as the privileges committee.
So the thrust of what you're saying,
It unsettles all the procedural arrangements at the committee level. So that, for instance, when the e-levy bill was referred to the Finance Committee was to determine whether or not the bill should be considered under a certificate of urgency. When members of my side, the chairman, who is Mr. Kweku Kwatin, had to exercise his casting vote to tilt it so it became 13-12. In the event that one member from the majority side had not attended, then Kweku Kwatin will now be vested with an original vote and a casting vote. So we would have voted amongst the 12 to make it
member.
Thank you.
And that is problematic.
That's problematic.
And
it will be applicable to all the committees.
Okay. Let me quickly bring in, because there are those who dispute that this is, as far-reaching as you put it.
Justice, and then let me on members holding office of profit,
right,
which is also another committee.
Okay. So a lot of loose ends to tie there, but just hold for me, Justice Abdullahi. It's really good to have you because very brief initial reaction to the ruling of the court and per its reasoning. What is your quick reaction?
Very simple. As I indicated earlier, on the day to the body politics of this country, and in particular, the House of Parliament. And naturally, as I said, I also have indicated my reservations about some of the orders made by the Supreme Court, and which is why I've indicated my preparedness to prevail going forward. It has brought about additional difficulties, which has yet polarized our systems, something I never expected, because I expected that in fact, the whole essence of me going to the Supreme Court was to ensure that the decision that will come ultimately from the Supreme Court will be more acceptable because it will not be tainted with any particular political party colorization.
Political party colorization?
No, not at all. You're not getting the point. The point is that the basis for me going, the basis for not waiting for an MPP or an NDC man to go.
Right.
Was for me to get an acceptable decision for all my entire reasoning behind going to the Supreme Court. My point is that, unfortunately, the decision as pronounced by the Supreme Court has rather furthered the polarization that I sought to stop. And that is the level of disappointment that I have with regards to the decision, which is why I've on the upteenth time indicated my readiness to ensure that the Supreme Court takes a second look at the decision and, if possible, review the judgment as delivered. Of course, if they reaffirm or reaffirm the decision as we have it now, sadly, we have to work with that because that is the final authority that we have in this country to the best of our abilities as a country. And forge forward in unison.
Justice, we have to be, I'm sorry, but we're constrained with time, so we have to be a bit more incisive so that we can digest all the matters at play. A very quick one, because I've listened to members of the majority side in Parliament, the MPP, who have suggested that you are tied to the apron strings of the NDC and that was part of why you took this matter to court and now things did not go. You hold a card. I mean, what are your ties to the NDC?
I am not a member of the NDC. I do not have a party card of the NDC. I'm not in any way associated with the NDC. And I think those bringing these matters up are simply ignorant detractors who are seeking with their little minds to detract me from pursuing the national agenda. But I don't get moved by such things. I would pursue the national interest to the best of my abilities. Indeed, I do not hold any political party card, whether MPP or NDC. I do not have anyone. I have very strong as an impartial Ghanaian, a patriot who is desirous of ensuring that the Ghanaian interest is projected and pursued at every level. This is my objective, and I'll continuously pursue that. I will do everything to ensure that the Ghanaian interest is protected and projected at every level, without having to have or own a political card of any other political party. I do not intend doing that, and I will never do that, possibly for the rest of my life.
Are you saying never? We say never because, I mean, you could in future, who knows? I mean, we've had even the likes of Professor Raymond Atuguba, who has served as executive secretary to a president. So by coming out in this matter...
I can serve in any government, and I'm indeed ready to serve in any government.
Okay.
That would be a clarion call on me to serve my nation. That is not to say that I'll take a party card in order to do that. If that would be the only qualification, I'll probably may never do it. Because I do not believe that having a party card is the only way to serve your country.
Right. Right before I go to the chairperson of the Constitutional Legal, yes, it's a decision by the court with many more problems, which opens a belly of problems to us. To what extent do you agree or disagree with the Supreme Court's ruling? And do you, on hindsight, regret taking up the matter in any way? So to what extent do you agree or disagree? And does the ruling make you regret taking it up in court?
First of all, I do not regret ever doing this. I'll probably never regret doing that. As a matter of fact, I'm more motivated. Somebody has to take the national interest at heart. Somebody has to pursue that. And if you leave it to the MPP and the NDC, you probably would never achieve that objective.
Right.
Second, I do, as I've indicated earlier, I do appreciate the decision as given. And I praise the decision because it brings the counting of deputy ministers in as part of the members of decision making. I completely disagree. Allowing a member of parliament to vote, I completely disagree. And the basis of my disagreement is that it takes away the impartiality that we seek in the persons occupying and presiding over any parliamentary session. I think that the best way we can get political parties so that they can put the national interest first rather than putting their party interest first. Remember, it's the party interest that has continuously detracted our development. And that is what I do not see as a positive step in this particular decision.
Right. Kwame Enyimadu Entry is chairperson of the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. He joins us via phone. Thank you so much, sir, for joining the conversation. So much. We're very grateful for your time. Now that we have the Supreme Court ruling on this matter, we know per the ruling itself, the detail of it points to the fact that it must now come to you in Parliament, specifically your committee, for use as part of your standing orders. How exactly do you intend going about this? And maybe even before you get into that, just indulge me here. What is your quick reaction to the Supreme Court's ruling? And then you can take that question about how you're going to implement this.
Well, okay. Good evening to your cherished viewers. There was, and I'm glad that the person that sent it to the Supreme Court, if I'm right, is with us.
He is.
And I would want to congratulate him for the step that he took as a national, a good national. He wants to be nationalistic and took a matter that is ambiguous to the court. If you look at the Constitution doesn't talk about the voting of the deputy speakers. But the standing orders, now it has lived with us. We have used it since the beginning of the Fourth Republic from 1992 till date.
Right.
But this is the only time that the interpretation of the clause, that is 109.3, came up, because this is the first time that we have gotten both majority and minority at par.
Right.
It has never happened. So the matter. I heard somebody say that, look, when Parliament had made its rules and the judiciary comes in to say that what you have done is not the right thing, those people are not comfortable.
Right.
But the mandate for whatnot, where people will think that we have to fight, we have to use our faith instead of actually trying to negotiate for us to understand the issues. And this clause was something that brought about a fight. And you hear people saying, but I think this Supreme Court decision settles it. They have the right. They have done the right thing. They have interpreted it to say that what we have put up in Order 1093 is not the right thing, and that same be struck out.
Mr. Nyamadu Entry, pardon my coming in here. You say it settles it, and that is in line, in tandem actually with what President Akufo-Addo has said. But it doesn't seem that way from the minorities' end. And at a point, I'll have Roxanne Nelson Dafiamekpo in mind. In fact, we've had the former president, John Dramani Mahama, talk about his distaste of the entire process and its outcome. We have had Roxanne Nelson Dafiamekpo, who is here in the studio, mentioned that it is a judicial coup against Parliament. We have had the Speaker of Parliament say that the ruling is absurd and reckless. And we've heard from the likes of Member of Parliament for Ningo Prampram Sam George say that they're going to contest it, apart from the review in court. They are talking. So how sure are you that this is going to go as smoothly as you're painting for us tonight?
Well, I'm not surprised. But I think I've heard the Speaker say in Parliament that the matter is sent to court for interpretation. So members of Parliament should wait for the outcome of the court.
Right.
And the Constitution says that the Constitution is the basic law of the land. And any be null and void.
Right.
And I think that is exactly what the Supreme Court had done.
In fact, in its ruling, the Supreme Court points to exactly that.
The rules. And I do not expect, you see, the person that even sent the matter to court, from what I heard him say, he is disappointed as well, because he was expecting the ruling to go the other way. He was expecting that, and he said that a deputy speaker should be impartial, and therefore he does not expect the deputy speaker to vote. So to him, my other colleagues who are saying these words that they do not agree with what the Supreme Court has said, it is a reaction to their disappointment. And
just to get it clear, yes, the minority may be disappointed, but are you suggesting as well that the petitioner, Justice Abdullahi, is disappointed? Are you impugning any political leanings to him? Or is it Roxanne that you are referring to, purely Roxanne?
No, I'm not imputing any political thing. He said he wanted to he spent it as a national of Ghana.
Right.
And he doesn't want to get a party card to actually make these decisions. He will remain neutral. But it doesn't actually make him a disinterested party. Those expectations were not met.
Okay.
That's how I analyze it.
Right.
But which is a disappointment. I'm a lawyer. We send cases to court every time. You think that you are on the right path. And the court may tell you that you are on the wrong path. And you get disappointed. And I think that is what is happening. It has nothing to do with MPP or NDC. But like Ananado said, to me, even before we went to court, I thought that this is something that is basic that we should understand it. But the one that was actually a problem was the 109.3.
Right.
And it doesn't exist anymore. It has been quashed as null and void because it is inconsistent with the Constitution.
Okay.
And I do not see it as a coup that the judiciary has made a coup. It is not in the best interest when the Parliament makes laws and then it is reviewed by the judiciary.
Right.
Quite recently, we made laws about registration, that you could use a national identity card, you could use whatever card. And if we included, I was part of that parliament, we included the national insurance card, that if you had a national insurance card, you could register. Then we had this professor doing the NI.
Maybe you can wrap with that very point you're making. Sorry for coming in, but
what I'm saying is that we make mistakes all the time. As Parliament, we made a mistake, and we're corrected by the court.
Right.
And I think the first Parliament had made a mistake, and they've been corrected by the Supreme Court. And I think it's within the rules.
All right.
Whether somebody is disappointed or not, it's not the issue. The issue is that with the Supreme Court on the right track. That's how we have to look at it.
All right. Thank you so much, Mr. Enyimadu Entwi. Gentlemen, we have a gamut of issues to consider, and we're already halfway through the show. So please be as concise, as precise as possible. Let me come to Dr. Rashid Draman. Now, you wanted, the last time we spoke last week, you wanted to see the ruling, in fact, the reasoning behind the ruling of the Apex Court. Now it is out there, and some have said there are potholes. It creates more problems, just as Roxanne Nelson Dafiamakbo has intimated in the studio. For you, what is your take now that you've seen the reasoning of the court? Positive, negative, and what do you think ought to be considered further moving forward?
Thank you very much, for having me. I think, looking through and reading the reasoning of the Supreme Court justices, and then going back and taking a look at the standing orders and our Constitution. Certainly, if you read Order 1093, specifically talks about deputy speakers or any other members presiding losing their original or casting vote. When you go to 104 of the Constitution, it only speaks about the speaker. So from a legal point of view, I'm not a lawyer, but from a legal point of view, even in looking at the standing orders, I've been involved. Recently, I was working with some of the advisors to the speaker to look at, the current revisions that are going on, the standing orders. And each time we take a particular order, we try to see whether it's in tandem with the Constitution. So maybe legally, the decision might be right. Politically, I'm not too sure. It has created, as the petitioner himself has said,
right,
more problems than he was looking to solve.
Right.
We are.
Do you see saying just briefly? Do you see saying that it has opened a can of worms in trying to address one problem? We've created other problems. Do you agree?
Indeed, I do agree. I agree mainly because, when you look at it from a much bigger perspective, and you take into account the current context within which we are as a country, this will be looked at more from a kind of balance of power perspective, more than just simply the issue of voting rights of of deputy speakers. So I think that from that point of view, that is where it creates a lot of political problems.
Right.
Over the last couple of weeks, months, we've been at trying to bring the two sides together. You've heard, the consensus efforts led by Dr. Ibn Chambers to try to bring the two sides together, and so on and so forth, and how that was interpreted, and further deepen the divisions between the two sides. So at this point in time in our history, I would have thought that, a lot of political careful thinking would have maybe been taken into account in arriving at this judgment. Because
but this was careful. This was a lot of careful thinking by the court. Are you saying they didn't think well enough?
Well, I'm saying that perhaps the political environment and the current situation that we find ourselves in, where Parliament is deeply divided than we have ever seen before, maybe the court would have said, for instance, on the issue of quorum, honestly, a deputy speaker who is a member of Parliament,
right,
I think should be counted in order to form a quorum, because I have seen in all the parliaments, by the way, we are one of the few parliaments in the world where our speaker is not a member of Parliament.
And I was just about to get to that, because you go to other jurisdictions, Canada, the UK, there are some precedents where, whether a tie or something, in fact, a lot of the time they are members of Parliament or whatever the issue may be. So I was just about to get to that. What is it, putting, considering the international context?
Yes, considering the international context, in Canada, in the UK, even in the US, our tradition is more derived from the Commonwealth. Most Commonwealth countries have speakers and deputy speakers as members of Parliament. And as much as possible, the presiding officers try to avoid situations where they get into voting during critical moments. Maybe at best, they will just have a casting vote, And if you go around to all these countries, when parliamentary proceedings are about to start, the speaker as well as his deputies are usually counted. I have sat in a number of parliaments where before parliamentary proceedings start, the speaker is counted, his deputies are counted in order to establish a quorum.
Right.
But when it comes to voting, once you ascend to that seat, I think there is a lot more to it than just simply saying that you are a member of Parliament.
So just do this for me, Dr. Draman. In 30 seconds, is this ruling more problematic than problem solving? How do you digest it? 30 seconds, so I come to Roxanne.
It is very problematic because, Benjamin, if you listen, since the ruling came out, I have not seen an NDC person who has supported the ruling. I have not seen an MPP person who has spoken against the ruling.
Right.
Is that what we want in this country? I don't think so. Okay. And that is why it is problematic. Because
thank you.
Justice Ablai was saying he was hoping that, a ruling will be given, and then all of us as Ghanaians will come around the ruling and say the court has settled it.
Right.
But now when you listen, and we have two honorable members from different sides of the House here on this show, and you have heard them. And we have heard the minority leader, we have heard the majority leader, we have heard the speaker, we have heard the former president, we have heard the current president. Anybody NDC or from that tradition has been against the ruling. Anybody MPP or from that tradition has been in support of the ruling. It is come to further divide an already divided nation that we have.
All right. Thank you very much, Dr. Rashid Rahman. Let me come to you now, Roxanne. And again, brevity is crucial at this point. What is the current thinking and posturing of the NDC on the back of this ruling? Like even Dr. Draman suggests, there are good aspects and there may be problematic aspects. Is it all bad?
It's all bad.
It's all bad.
It's all bad. For instance, if you take page 3 of the judgment.
And quickly what you're going to decide.
The Supreme Court have the vote. You see, Parliament is a house of records.
Right.
So are our courts. The Supreme Court conveniently relied on the votes and proceedings of Tuesday, 30th November,
Right.
2021. But somehow ignored the votes and proceedings of Friday, 26th November,
Right.
2021.
Which is the first time when
Which is
the
the
budget
first time.
approval was
The number
came to
of
Parliament.
members present was 274. The Supreme Court somehow said we were 137. And this was the basis upon which they determined issue 3.
Out of the 8.
Out of the 3 issues set down for determination in the case,
Right.
issue 3 borders on this. It turned on whether or not to be present in Parliament. What does it mean? How many persons were present on the 26th, on the night of 26th November 2021? Supreme Court said we were 137.
So that's a fundamental problem.
The votes and proceedings said we were 274.
Right.
So that for me, it's a very major problem.
Because it was the majority and minority in Parliament before.
Yes, if we are in Parliament, you
took
walked
place.
out, that's your business.
Right.
So that's one. 2, there were 2 other suits in respect of this matter. So normally you expect the Supreme Court to consolidate these actions and make a determination. What is the fate of the other 2 suits? One filed by Richard Sky and the other by my friend Andy Apiakubi.
They may be similar, but we have a ruling on this one. We have a ruling on this one.
No, that's not the practice of the court. When you have similar actions filed in respect of a matter that is topical, you consolidate and you determine.
So the apex court erred.
I don't know. But so I'm asking,
I mean, if you're saying that, for example, they did not.
No,
they did
these
not,
are matters of fact.
take into account what happened on the 26th of November.
Exactly.
And that they are also not considering that there are similar suits which they have to consolidate. You're basically saying they are in error.
Yes, in terms of the statement of the truer facts. When you go to court, you have the defendant set of facts, the plaintiff set of facts, and the court's finding of fact. So the court's finding of fact now becomes the facts of the case.
Okay.
The courts in determining the facts of the case completely ignored a very material evidence from Parliament, which is the votes and proceedings of Friday, 26th of November, based upon which they determine issue 3.
How bad a mistake is that?
It's so material that based on this, we could go back to court and have this decision jettisoned.
Quickly, hold it right there for me. Justice Abdullahi,
Yes.
have you averted your mind to this particular error as well? Do you agree with Roxanne on this point? And is that one of the reliefs you're going to be seeking as you petition the apex court?
This is relief 3. This is the decision.
Okay, so this is it. Indeed, there are other pending cases that the Supreme Court indicated on the first sitting of this matter that they intended consolidating. However, upon I think the next sitting, when the Supreme Court adjourned the matter, we came back and they had changed their position that they wanted to give judgment on mine. I think possibly because everything was set for mine, and so there were no other reasons for it to be held back for judgment to be delayed. That is my belief. They didn't assign any reasons for the change of their minds, but I assume that it's because everything was set for mine. Indeed, on the first sitting, the Richard Sky's case was called and it was adjourned for other reasons. So I think these were not consolidated. And let me point out that the fact of the non-consolidation does not in any way amount to an error. It's purely at the discretion of the court.
It's an established practice.
Yes, of course. It is a practice.
Right. So that is clear. That is clear. You're talking about established practice, right?
But it doesn't make it an error when the Supreme Court decides not to consolidate anymore.
I didn't say so.
Okay. So the bit about the numbers on the 26th, is that a fundamental problem, like Roxanne is pointing out, that there were 247? You said
274.
274. That is.
Yes. If the set of facts, right, at this moment. I am still going through the researches to do. I mean, I'm drafting my review application, and so when it's finally ready, we would discuss it further.
All right.
However, indeed, if the material fact is used such that it influences the court to give a decision otherwise than it would have given, naturally becomes an issue that would grant a possible application for the facts to be
looked at
again. Because it could have changed the outcome of the case.
Thank you for...
so generally, yes.
All right.
Yes, my final point.
Right.
The point has been made about the status of the two deputy speakers. Now, as if they are ordinary members of parliament. By our constitutional provisions, the president is supposed to appoint at least 50% of his ministers from parliament. Now, if by parity of reasoning, can the president appoint the two deputy speakers as members of parliament if they say they are ordinary members of parliament with votes? Is that possible? Under our constitutional architecture? While serving as deputy speakers of parliament, could the president have appointed them as ministers, sector ministers? So you see, when you leave Bekwa, you leave Formina, you become first and second deputy speakers. You are quite special status.
So let me just quickly get this. Are you going to resist any attempt by any of the deputy speakers to vote on matters in Parliament? For example, as the e-levy has been tabled for next week.
No, the e-levy is not tabled for next week.
Well, it's been intimated that we're going to be considering that.
E-levy, they don't have the numbers. They are running their polling station elections. All their members are seeking their
but for any matter of this nature that will come up, what is going to be your reaction?
I'm just making the point. The point is that the court itself says that they are leaving the practicalization of this right
to your committee in Parliament.
No. To Parliament itself to determine.
Right. But I'm saying that, I mean, eventually it will come to your committee.
Yes.
But I'm saying that, so on the matter of the e-levy, for example, with the court's ruling, what is going to be the reaction of the NDC? You have said in the past that you would resist it.
It's a bridge. When we get there, we'll cross it.
So for now, you don't know what you're going to do?
No, we don't know.
Let me come to Mr. Nyimado Entry, and thank you for being so patient. Now, I asked you earlier something you did not really get down to. It had to do with how you're going to execute this plan. Just like Roxanne was mentioning, just as the court's ruling dictates, you as Parliament are going to have to enforce this. Now, it's being said that there are problems with it. Dr. Draman has said so, Justice Abdullah has said so, Roxanne Nelson, Dafia Mekwa has said so as well. How are you going to implement this, incorporate it into the standing orders of Parliament, and how are you going to do that considering that there are problems with the ruling?
Okay. Thank you, my brother. I do not think that there are problems. My colleague would agree with me that if you look at the Constitution is talking about the Speaker. The Constitution doesn't talk about the deputy speaker. And now the rules that were made and had actually stood up to date talk about the fact that the deputy speakers should not vote. That clearly there is a conflict. And we had somebody who is benevolent and a lawyer going to court to seek interpretation. We have gotten the interpretation. We are not going to struggle to interpret it because the Supreme Court says that is quashed because by virtue of the Constitution, it is in conflict with the Constitution, and to that extent, it's null and void. So that had been struck out. So that portion is not part of our standing orders now. And something that is not, when we say something is void ab initio, it means that we should treat it as if it has never existed. So implementing it is very easy. We are not, that's very close in the standing orders. We are not going to look at it because it doesn't exist. That's the whole thing. And my friend is talking about people, quorum, people that have come. I have not been privileged to actually read the reasoning of the court. But my brother would agree with me that the proceedings that he owed to say that these number of people were present and whatnot is different when we are taking a decision. You look at Article 104 and it talks about the fact that members, we should get at least one half of the members present. Somebody walked out, somebody has come in at first and has signed and had walked out or attended a meeting. When we are making a decision within the House, That number.
When you walked out of the budget, were you attending a meeting?
Hold for me, Robson. Hold for me,
Were you
Robson.
attending a meeting?
Go ahead, Enyimadu Entry. Go ahead.
At that material time that the decision is going to be taken, you don't have to go out and count all the people that have signed and had come to Parliament and had left. We are looking at people that are present in the House.
What record did the Supreme Court rely on? That's my point.
It's different from Article 104. Article 102 talks about the quorum to actually do business. But Article 104 talks about the fact that when we are going to make decisions,
this is fallacious.
Of Parliament,
this is fallacious. This is fallacious. Listen to the court.
Hold for me, Roxanne. Hold on.
Yes.
Let me bring you in at the right time. Enyimadu Entry, please hold for me. Roxanne has an interjection. Quickly, what is your interjection?
At page 3 of the judgment, the court said, in a challenge to the ruling of the Speaker, the majority asked that the vote be retaken by division. Before the revoting, the majority walked out from the chamber in protest of the exclusion of the Minister for Finance from the chamber before the vote. So how could you say that at the time of voting you were not present?
Quick reaction, Enyimadu Entry.
This is the judgment. I'm not the one saying this.
Please hold on, Roxanne. You've posed the question.
What Honorable Dafiamapo is saying, I do not need to read the judgment because I was an active participant. When it happened, I was there. We walked out. And therefore, the number of parliamentarians left in the House was less than one half. The following day when we went, the NDC went out.
We didn't go out. We were not there at all. We were not in Parliament. That's the difference.
Okay.
There's a difference.
So the number of people
you were there and you walked out.
Roxanne, please let him make his point.
Was up to one half, and the decision was made.
Okay.
And that's what Article 104 talks about.
All right.
That at least there must be one half present, and then they decide by majority decision.
And I think that horse has been flogged enough. So I'm asking you, what next now that the ruling has been delivered? And yes, there's going to be a review supposedly from Justice Abdullahi, who is going to petition the court for that review. But as it stands now, how are you going to implement this in Parliament? Can you, in some 30 seconds, just walk us through what we can look at as a country, look forward to?
Well, I think that we cannot actually exclude political lines from these thoughts. MPP, NDC, already we're voting, and we are all political. MPP has gone one side, NDC has gone one side. If there is a decision and the interpretation that would actually tilt to one side, obviously one side would be disappointed, and then the other side would say that, oh, I think this decision is reasonable. But I think that I am being objective here. And I think the decision that the Supreme Court has made, it is going to be with us for, unless we make another rule which is consistent with the Constitution, this 1093 of the standing orders is dead and gone.
All right. Thank you. Right. Thank you for clarifying that. Justice Abdullahi, so you have intimated that you're going to seek a review. I mean, are you still going through the ruling, the reasoning, and all of that? What timeline should we look at in terms of seeking this review? Because you would acknowledge that time is of the essence.
Well, until the last day, we cannot make any final decision. I need to emphasize that I do appreciate a lot what Mr. Enyimadu Entry has said. I think so far he's one of the few reasonable minds I've heard from the government side.
Reasonable minds.
In Obiamo and other few persons who have really been objective about this. We need to understand that whichever way it goes, even if the review application is heard and is granted, it will still favor one side of the political divide. Right. If it is refused, it will still further favor one side of the divide. So that point, as he makes, should be accepted at this moment. And as I indicated earlier, whichever outcome we get, whether I go for the review or do not go for it, whatever outcome we get out of this whole exercise should be something that all of us would have to buy into and work with. At the end of the day,
quickly, very quickly. So that means that you may actually not go for the review. I mean, from the way you're sounding, you may not go.
And my processes, and I'm still going through everything.
Right.
And my point is that even if I go for the review, it could still be rejected. It's not as if the fact of going for the review is automatically going to change.
I mean, 7-0 to nothing. It's well nigh impossible, isn't it? I mean, why are you even wasting your time, so to speak?
Supreme Court does not work with numbers. You do not pretend that the people there are unreasonable people. They do not have the humility to change their mind. Whoever thinks that way is wrong. I mean, we are not dealing with math here. We are dealing with logic. We are dealing with law. A person who gave a decision yesterday can sit back and in all humility accept that perhaps if he had adverted his mind to a particular area, which he are now adverting his mind to, he probably would have given a different decision. And so on the basis of that,
I like that spirit.
If you sit back thinking that everything is about mathematics, you are completely wrong. Constitutional matters are not organized and
right. So you're hopeful that you can overturn this decision, that you can get a review.
Absolutely. It's about convincing the members, the panel. It's not about counting who voted what and who decided on what. That's not how it works. So those counting 7-0 and 9-0, please, they should revisit.
No, just to clarify, so you believe that you can actually get a reverse decision?
I believe that I'll be in the position to convince them to look at their decisions again. If they come out affirming the previous one, why not? We thank God and we move on.
All right.
We pick up the pieces.
So
That's what we do as a nation.
Concluding comments, gentlemen, in the next 2 minutes or so, we should be wrapping up. I'll start with you, Dr. Rashid Draman. So in the midst of all of this, for you, in less than a minute, if you can, what do you see to be the way forward? How do we resolve this mess?
Well, I think, Benjamin, in our recent political history in this country, we've had some precedents. Our sitting president has had to disagree with the Supreme Court at one point, but he said he accepted the decision. Our former president, President Mahama, has had to disagree with the Supreme Court, but accepted the decision so that the country would move on. I'm just hoping that these precedents would guide maybe the NDC side in Parliament, even as they disagree, and it is within their right to disagree with the ruling of the Supreme Court, but in the interest of bringing the country together, maybe they do accept it so that we move on.
All right.
Because look, if you are going to take 1093 out of the standing orders, and you are going to revise certain aspects of the standing orders, you need the two sides to sit together in the House to get this done.
Okay.
If they don't agree and see eye to eye, we are going to have further confusion in the House, because we are going to have standing orders that they do not agree with. And that's the book that guides every proceeding in the House.
Thank you. Thank you, Doc. Let me quickly bring in Enyimadu Antwi. Some 30 seconds to wrap up. Your final comments moving forward.
Right, sir. I think that we have had more polarized decisions, as my brother just said. There had been 2 election petitions before the Supreme Court. And that, I am sure it was more political than any other issue, because the country was divided along that line. MPP, the first petition, MPP was disappointed, NDC was happy, the second decision, vice versa. But we calmed down, and I think that this decision, no matter the disappointment that one person belonging to NDC or NDC would have, or happy, the person being very happy with the decision. I think that as the petitioner, Justice Abdullahi said that the Supreme Court judges may sit and then come out to review their own decision.
Okay. All right. Thank you. Thank you very much, Mr. Enyimadu Antwi. You have about 20 seconds. We're about to wrap the show. Roxanne, your final comment.
Let me quote Chief Justice Acha CJ.
That'll be your final comment.
Yes, in the matter of NPP versus
Please go ahead. Time is of the essence. We're wrapping up.
As a dissenting opinion, he says the Constitution 1992 gives the judiciary power to interpret and enforce the Constitution. And I do not think that this enabled the Supreme Court to do what it likes by undertaking incursions into territory reserved for Parliament and the executive.
Okay, thank you.
I'm saying that this appears to be a judicial solution to an intractable political problem in the House.
Thank you so much. Joining us for the discussion, Dr. Rashid Rahman, Africa Center for Parliamentary Affairs, Roxanne Nelson, Dafia Mekbo, Member of Parliament for South Dai, also a member of the Committee on Legal and Parliamentary Affairs, Constitutional Legal and Parliamentary Affairs, together with Kwame Enyimadu Entry, who is actually chairperson of that committee, and Justice Abdullahi, a lawyer and law lecturer with the University for Professional Studies Accra. Gentlemen, thank you so much for the enlightening conversation. The conversation, of course, continues as we break down this ruling by the Apex Court. This has been The Probe right here on Joy News and other channels. My name is Benjamin Akakpo. Do have a good night.